Day. This is the Planning and Land Use Management Committee. I'm Councilmember Jose Huizar. I've been joined by Councilmember Marquise Harris Dawson, Councilmember Gilbert Cedillo, and Councilmember Felipe Fuentes, the way it's listed on my thing. And we will go and start with item number 7.
Item 7, Councilman, is the weekly Director of Planning's report.
Mr. Bertoni here? No, I thought I saw him in here. Okay. Well, no one filed that item. We will continue item number 4 to April 5th. Item 4 continued to April 5th. Okay. Item number 5 continued to April 5th. And item number 2, approve on consent if there are no objections to that.
So that item, Councilman, we're approving the City Attorney ordinance.
Yes, can you read that into the record, please?
Yes, it's City Attorney Ordinance, Councilman, to amend various sections of the Municipal Code as it relates to damaged buildings after a major earthquake in the City of LA.
Okay. Thank you.
Mr. Bertoni is present.
Thank you. If we could go back to item number 7 and reopen that one up, please.
Sure, it's the weekly report by the Director of Planning.
Okay, welcome.
Thank you. Thank you, Chair Huizar, members of the committee. Just real briefly, you have a full agenda. This week in our City Planning Commission meeting, they'll be considering revisions to the parks fee, or better known as Quimby fees. So that'll be coming to City Planning Commission this week, and then after that will be in our meeting at the Van Nuys City Hall in the San Fernando Valley, and then once they make the recommendation, that will be forwarded on to this committee.
Thank you. We have a couple of speaker cards for item 7. Wayne and Herman.
Yeah, for the record, my kids, they got no schedules in the back there. So we don't have no way to know what we're talking about. We got no agendas back there. So I know you writing reports over and over and over again. Upstairs we had reports. It's time to stop writing all these reports and get to action. We need to get action instead of just writing reports. Get out there with those bulldozers and bulldoze the convention center like in that report. That was a good recommendation. Thank you for recommending bulldozing the convention center. But the black folks want to take it down, but the white folks, they want to put hotels next to that white elephant in the black district. So I urge my black brothers and sisters to vote to get rid of the convention center, tear it down, don't build any more hotels there, and give it to the Dodgers and let them build a new stadium, and then up and
reflect what we built. So like I said earlier up in the last meeting, I believe we should just tear, oh, here we go. Here's an agenda, sir. Item 7, Director of Planning Oral Status Report. Retaliatory to ongoing development in the city planning, policies, work, programs, operations, and other items of interest without due process. There you go.
Good. That's item number 7. We'll receive and file item 7. And item number 2, which we just proved on consent, there was a speaker card. Wayne, item number 2.
Yeah. Now I got me an agenda. Thank you. Thank you very much for Marquise giving me that information. Now, damaged buildings after an earthquake. Like Mama told me, you broke it dead. Once there's the earthquake, you just take that shit, let it fall down, take a bulldozer. That's why they got companies like Kubota, and they got companies like John Deere that make real good bulldozer. And we're just going to bulldoze that shit down after that earthquake. Yes, sir. Yeah, 1992, we had our riot. And now we're going to have the earthquake, and Jesus going to rectify the situation, these white motherfuckers, by taking their houses down. We're going to bulldoze and we're going to build affordable housing all over the city after that motherfucking earthquake. So let's not save nothing. Let's let it fall motherfucking down, and once it does, we build affordable housing like the Lord intended.
Okay, so item number 2, we have approved on consent with no objection. And now we will go to item number 1, please.
Sure. Councilman, item 1 is a issue that was in committee last week, and since then, a motion by Councilman Farrel was introduced relative to the homeless shelters during the 2016 El Nino cycle.
Thank you. And this item was in plum last week, as you know, but we agreed to hear it again today because some our colleagues had some questions, particularly Councilmember O'Farrell. I do want to share with the Plum members the clarifications that have been discussed with the city attorney and city staff. Number 1, the CAO has developed an online portal for providers to use in registering their shelters and to submit the necessary documentation. And number 2, this registration will automatically notify the appropriate council office and neighborhood council. I want to thank Councilmember O'Farrell's office for helping us to improve this ordinance, and in fact, it will help us to improve our overall ordinance for the long term. As you know, this ordinance is extending our winter El Nino shelter crisis for 90 days, and although we may not have El Nino visiting us as was expected, it did help us begin to venture in this policy arena in a new way of thinking about how we could provide more shelter in inclement weather for those who need it. This will also help us as we work towards a more longer-term solution for additional shelters throughout the year. We have some amendments here that we came up with along with Mr. O'Farrell's office. I'd like to read them now and ask the city attorney to include it in their ordinance for tomorrow. But if there are any questions or comments, we could entertain those now. No? Okay, so if I could ask, so confirming the change from last week to an 80-day term, I would like to further amend the ordinance to include that providers register with the City of Los Angeles by submitting an online application, that providers comply with the cold, wet weather temporary shelter requirements of the fire department, that providers provide written notification to adjacent properties, any school, to adjacent property and any school located within 500 feet of the site prior to operating a shelter, that providers comply with all requirements that apply to the primary use of their property while operating a shelter for the homeless. And also, I move that we receive and file the motion that was included in today's agenda. Because of the urgency of this item, it is at council tomorrow, so I'd like to request the city attorney to make those changes in time for council tomorrow. Is that possible? Okay, great, thank you, and thank you for your work on this, by the way. Any questions or comments on that? No. Okay, so with no objection, we'll move that item with those amendments to council tomorrow, and the city attorney will prepare those for council tomorrow. Thank you. Next item.
Would you like to take item 3, Councilman, the target?
Okay, number 3 is the next item.
Number 3, Councilman, is an appeal and various land use entitlements as it relates to the construction of a new Target store in Hollywood, and the appeal was filed by Target itself and also by Doug Haynes, and that's what's before you.
Okay. Welcome.
Good afternoon, Shauna Bonston with the Planning Department. You've seen this case before, but just to brief you, the case before you is a proposed Target shopping center located in Sunset Boulevard in the Vermont Western SNAP specific plan in East Hollywood. The case went before our Planning Commission on November 12th, 2015, and at the meeting, the Commission unanimously recommended approval of all the entitlement requests, including a specific plan amendment to the SNAP to establish a new sub-area F to accommodate the development, and to reclassify the subject parcel of land within the new sub-area. As well, a general plan amendment to reclassify Sunset Boulevard and Western Avenue as modified streets, a conditional use permit for a full sale of alcoholic beverages for off-site consumption, a specific plan project permit, and a site plan review. The CPC also found the addendum to the project's EIR as adequate environmental clearance. In addition to the Commission's recommendations of approval to your committee, there have been 4 appeals filed against the project. 3 appeals are by project opponents, and the 4th appeal is filed on behalf of Target. Target is appealing 2 conditions of approval. One is regarding the child care provision, and one is regarding indemnification language. As part of their appeal, Target has submitted a fee study to demonstrate that the monetary value that would be required in order to accommodate their employee child care needs. Our position remains to approve the project as recommended by our commission and deny the appeals. One final note of an update. Since we last met with your committee, a motion was introduced by CD13, which was heard by the Arts, Parks, and River Committee on Monday to direct the CAO to evaluate child care needs and request the Board of Rec and Parks Commission to consider the applicant's proposal once the review is completed. With that, I'm available for questions.
Great, thank you. We will go into public comment now. And there are 4 appellants. We'll begin with each appellant has up to 5 minutes. All other speakers have 1 minute. The first appellant is George Abrams.
Abrams. Thank you for taking the time to hear from us today. You know, this is a project that I've been involved in from the very beginning. Back in 2009, when I was a member of the neighborhood council in the area, I was the president of the East Hollywood Neighborhood Council. I was a member of the Hollywood Studio District Neighborhood Council, and the initial project was released with an MND. And we came here time and time again and we said, look, an MND is not going to work. And the people that I represent in this community, not only as on the neighborhood council as their representative, but as an attorney, have only one thing that really gets them a seat at the table, and that's the law. And if the law is not being complied with, they have only one other option, which is litigation. In 2010, I was involved as an attorney of record in the initial lawsuit filed against the project relating to the MND. Target at that time withdrew its approvals. We went back to the drawing board. They did an EIR, and then the project was again approved, and I was again involved as attorney of record in the litigation, which, as you know, has resulted in the project being stalled in the place that it is. Of course, Target began construction on the project in the midst of this litigation that any first-year law student could have told you was highly likely to succeed. We came here time and time again and we said, look, the exceptions to the specific plan are not supported by the law. There will be litigation. It will happen. And now we're saying the same thing. What's happening now is the city is proposing creating an entirely new sub-area within the specific plan, amending the specific plan that governs essentially the heart of Hollywood, amending the general plan as well, creating an entirely new sub-area, and saying that they can simply take a stapler and staple an addendum onto an existing EIR and that that's going to be good enough. Well, it's not going to be good enough, and there will be litigation again over this issue, whether or not an addendum is sufficient. The standard is fairly easy to articulate. If you look at the case of Ventura Foothill Neighbors versus County of Ventura, that was a situation where they had issued an EIR for a project that was originally 75 feet tall. They increased the project to 90 feet. And they said, well, an addendum to the EIR, since everything's the same and it's just 15 feet higher, is going to be fine. And the court said, no, that's a major change to the project. Here we have an amendment to the specific plan creating an entirely new sub-area, okay, in the SNAP, okay? That is a new project for which a new EIR needs to be created. It will happen. The courts are going to look at this and they're going to say, yeah, you got to do an EIR. Now, of course, when the EIR ultimately comes out after this phase of the litigation prevails, there's going to be litigation again, right? Because we all know the EIR is going to be incomplete as well. And so that's the way it happens in Hollywood. That's just the way it is. It's planning through litigation. But at this point in time, right here, it's up to you guys. Are there going to be 2 lawsuits, or is there only going to be 1? Are we going to have a lawsuit about whether the addendum is proper, or are you just going to go back and do an EIR? Because if you just go back and do an EIR, we can skip to the second lawsuit right away and skip the first lawsuit altogether. I don't predict that's what's going to happen because the history of this project has been one step in the same puddle over and over and over again. And, you know, for any bloggers or members of the press or whoever's here, when they write their articles pointing their fingers at alleged NIMBYs that are getting in the way of this project, when for 7 years I've been coming in front of these committees and saying, look, just do it right, people. Just do it right. We've been saying it over and over again. We don't have the luxury of allowing the law to be ignored in Hollywood because the law is all we've got. That's the only tool we have to have a seat at the table. So just stop, think, ask somebody. If you know a friend who happens to be a land use attorney, call him up on your phone and ask him whether he thinks an addendum to an EIR is sufficient to support a completely new sub-area in the specific plan that governs Hollywood. It's not going to happen. Stop and think about it. At least try to set off on the right foot. I'm tired of all the litigation, frankly. I'm tired of it. I don't want to do it anymore. So, thank you.
Thank you. Mr. Abrams, do you wish to, you have a minute that you could speak. That was your representative. Do you want to speak now or let the other appellant speak and then you speak, whatever you wish? Pardon me? Okay. Rich McNaughton, appellant.
Afternoon, honorable council members. I represent CCLA, the appellant in this case. We've heard from a lot of people in the community that they're very interested in the Target store being built, and they are very upset that litigation is holding up the Target store. So I'm going to give a brief overview of the reasons and how we can get the Target store built as fast as possible. Back in 2006, Gail Goldberg, when she first came here as planning director, she admonished the city that the process of allowing developers to change the zoning to fit the project was leading to disaster. She says the proper way to do it is to make the project fit the zoning. 4 years later, after U.S. Census came out, CD 13, which was perhaps most notorious for changing the rules or ignoring the rules and pushing through projects, ceased to qualify as a legal council district. Now, I know that some people that suffer from triskaidekaphobia thought it might be a good idea to get rid of a council district number 13, but we had a law from 1925 that requires up to 15 council members. So as a result, CD 13 took large bites out of Koreatown and out of CD 4, and it continues on to this day. Some of the downtown leaders behind Hilda Solis and Mickey Cantor formed the 2020 Commission, and as in their December 2013 report, they decried the crumbling state of the infrastructure and how atrociously the city was being run, and their call to arms was ignored. Just last week, we had the international group, INRIX, at least that's how I pronounce it, gave the scorecard for traffic congestion, and the city of Los Angeles has the worst traffic congestion in all of Europe and all of the United States. They also found that we had the slowest growth in gross domestic product, we had the worst growth in population, and we had the highest unemployment in the country. So I think that Director Goldberg, what she had to say about disaster was correct, because the policy of allowing developers to set zoning has become the standard operating procedure in Los Angeles. As we know, we've had the first stab at a community group with the Neighborhood Integrity Coalition. We've had the ballot proposal for November attacking this very thing. They called it spot zoning. That's been put off until March. Now we have this project, which perhaps is the poster child for spot zoning. We now have a developer who wants the city council to change the law so it can build a project that the courts have declared illegal. Now, we're not talking about some old, antiquated law. We're talking about SNAP, which came into being in 2001, and before it was even a decade old, the city council thought that, well, we can just ignore it because that's the way we do business all the time. Well, Judge Fruin didn't agree, and I doubt very much that Judge Fruin is going to agree the next time that you can just change the law as blithely as you ignored it last time. Now, when it comes down to someone appealing this, obviously CCLA can appeal a yes vote, but Target can't really appeal your refusal to change the law in their favor. So if you want to have a Target store built as fast as possible, the thing to do is to stop all this nonsense of changing the sub-area SNAP, vote no on all of this stuff, and leave Target the option that it should have taken in the beginning. Build a store that's by right, and you can do right by your constituents. Thank you very much.
Thank you. This is a warning to both Doug and Herman that, Doug, right? No, Spindler and Herman. I will consider your waving arms and standing up as public speakers are speaking a disruption of this meeting. Should you continue, I will ask you to leave. You've been warned. Thank you very much. Doug Haynes is the appellant, and then Daniel Wright, representative. Correct? Okay. Is Doug Haynes speaking?
Afterwards.
Okay.
Is that okay?
Yes.
Okay. Thank you for confirming that. Daniel Wright of the Silverstein Law Firm on behalf of La Mirada Avenue Neighborhood Association of Hollywood. Let the record reflect that we have submitted to the record today our March 22nd, 2016 analysis of the city's proposed use of an addendum in this case, as well as about several hundred pages of supporting evidence and documents that has been signed off by the clerk. In this case, council members, obviously this issue already has kind of generated emotion. The community is clearly pretty upset about the city proceeding in a way in which is continuing in a lawless path, a path now that seems to be focused solely upon legalizing a building that was arrogantly and illegally constructed against the law at the full financial risk of a multi-billion-dollar corporation. So it's not as if Target couldn't survive being required to comply with the law by making the building modified to comply with the law. But the biggest problem, I want to focus upon on the environmental issue. Never mind we talked about the policy issue of trying to legalize illegal buildings. It looks bad in the press. But more significantly, if a staff insists that this proposed action today only applies to Target, which we contend it does not, but even if it does, even if that's true, then there is indeed a spot zoning which essentially confers a special benefit upon Target to the exclusion of the benefit of other similarly situated landowners nearby, and that is a basis for invalidation of your actions again. But we contend that the overall evidence is clear from the record and the addendum that that the creation of the sub-area F is a new project. Nowhere in the original EIR did it say that, quote, it's establishing a land use regulations development standards and design guidelines for new sub-area F for large-scale highway-oriented commercial designation. You won't find that in the original EIR, but that's the proposed action. So in other words, the notice of preparation and all of the public comment that was submitted on the original EIR never, ever looked at the idea of creating new sub-area F. In fact, the project description specifically states that goes into details about how the project, with exceptions to the specific plan, would quote-unquote comply with the specific plan. That is now obsolete. So this is a new project. It is a new action. It has never been exposed to public comment and the rigors of environmental review. And for that reason, the use of an addendum is inappropriate because this is a new project, not an addendum. You can't weave it into the original proceeding and ignore the fact that this option was never analyzed. Additionally, there's overwhelming evidence that this creation of sub-area F applies to more than just Target, in that the language that's proposed for the changes in front of you includes a requirement for transitional heights where the project is adjacent to residential neighborhoods. Target is not adjacent to a residential neighborhood, which means those transitional requirements that are being created as part of this action that clearly would apply to other types of projects that could qualify under this sub-area F and not to Target. So that's evidence that you're creating something that applies to multiple future projects. You haven't analyzed that, and you haven't disclosed that to the public, and that is inappropriate. I also want to bring to your attention that in the letter of determination that was issued by the Planning Commission, it still says that on condition 47, with regard to the child care requirement, that it needs to be resolved prior to issuance of the certificate of occupancy. That is inconsistent with SNAP. You should be changing that to make it a requirement to be resolved prior to the issuance of building permits. For all of these reasons and the reasons submitted in our papers today, we would ask that you send this project back and require a compliant project to be considered. Thank you very much.
Thank you. Doug Haynes. Okay, and you have one minute, Mr. Haynes.
Thank you very much. My name is Doug Haynes with the Lamrod Evan Neighborhood Association. We've come before you for now 6.5 years on this matter. Just to reiterate a few things really quickly that I've said in the past that I think are important to remember. I'm from Roseville, Minnesota. I grew up in the area. I remember the first Target. That was a different era. It was an era when people still remembered World War II and the Depression. The Dayton family was part of that era. They were wonderful people. Unfortunately, Target today is nothing like that. I have fond memories of going to Dayton as a child. Irrespective of that, Target originally intended to construct, as I mentioned previously, a one-story co-compliant store. I spoke about this at the last plum meeting. We've submitted, there's been, from just us, about 2,000 pages of objections over those 6.5 years. There's been 29,000 pages total. No one's ever read any of that. No one's ever given us an opportunity. We've been right all along. I would ask that you just reject this project and let it be code compliant instead. Thank you.
Thank you. The applicant and appellant, John Dews.
Good afternoon, Chair and council members. My name is John Dews, Regional Development Manager with Target Corporation, Minneapolis, Minnesota. Just briefly, I just wanted to say that we are in concurrence with the proposal as it has been presented to you today, with the exception of the appeal that we have and that we understand of a proposed condition modification regarding the child care to allow for the in lieu fee. Other than that, though, as I said, we're in total alignment with the remainder of the proposal here. And we do have a number of our project team members here in case there are any questions of the committee from us. Other than that, I thank you for your time.
Thank you. Carmen Mock. Richard Schulman, or I can't make out the language. Okay. Thank you. Welcome.
Thank you. Hello, my name is Carmen Mock. I'm a Senior Group Vice President for Target Stores here in Los Angeles. I'm here today to emphasize my support of this store. In 1983, we opened our first Target in Los Angeles. It was a proud moment for us. Today we have 100 stores across the area with over 20,000 team members. This new Target store will mean hundreds of jobs added to our team, as well as tax revenue for the city of Los Angeles. Many of you may shop at Target, but for many reasons, I am proud to be a team member of Target's for over 30 years. And I'm proud of more than just what we do in the business. I'm proud of how we serve in our community. Target gives over $4 million per week into the communities in which they operate. Last year, Target made local philanthropic donations of nearly $5 million to the LA area. On top of that, I'm especially proud of my team members. We volunteer thousands of hours every year. I ask for your support in moving this project forward, and thank you.
Thank you.
Good afternoon, Richard Schulman, counsel for Target on this matter. Target withdraws the request for the general plan amendment for the two roads, Sunset and Western. That's item number 1 on the planning department transmittal. Only that item, though. Thank you.
Thank you. Mark Kenyon, Gilbert Mora, Jim McQuiston.
Good afternoon, council members. My name is Mark Kenyon. I'm here on behalf of the Mount Washington Homeowners Alliance on item number 6, but I saw this one on the agenda and I couldn't not stand up to object to it. We would see this as possibly the worst case of spot zoning that we're aware of in the city of Los Angeles, and we believe that changing the specific plan and or the general plan by the process that you're using here to be really a violation of the whole trust that the city has with the citizens in the creation of our specific plans and our general plans. We think that changing the specific plan by using an addendum to an existing project EIR is simply unacceptable. And then finally, I learned something new today, which is a feeling that I have personally had over I've been doing this on behalf of our community for over 30 years. And really in the last 5 to 10 years, this idea of planning by litigation seems to be happening more and more, and we really don't want that to happen. We would ask you to support the community on this. Thank you.
Thank you.
Good afternoon, Councilman. My name is Gilbert Moore. I am the Provision Coordinator for Behavioral Health Services in Hollywood. I am addressing another aspect of this project. the CUP or CUB that you guys are approving for it is, from my understanding, in perpetuity, meaning that it's never going to be reviewed once it's issued. I don't know what the practices are of the Planning Commission, but I assume that going forward that the review process would be like every 5 years at minimum for CUBs. As you know, Hollywood is, well oversaturated with alcohol licenses, and adding another one in a neighborhood area which has already been proven to be oversaturated would be just a disservice to the community and to youth in that area, which is part of my mandate, is to protect the youth from underage drinking.
Thank you. Jim McQuiston, Alicia Witzling, Chance Mortorell.
Jim McQuiston, you have my 2 statements on this, and of course I put in some before. They give you some ideas. We're supposed to be planning. Planning means thinking ahead. One of the problems that is really choking Hollywood is the streets are not wide enough. And these buildings that are being built out to the sidewalk don't allow major streets to be widened so that people will come and shop there because there's too much traffic congestion. And these things we've been working on, I've been working on for years and years now. And I am upset that this building was allowed to be started when actually it should have been set back to start with. And I cannot see why we can leave this building in space. You know what happened on Fountain when they built out to the sidewalk? It just stopped everything and we lost a good major street. Now Fountain is so congested you cannot move on it.
Hi, Alicia Witzling with LA Chamber. On behalf of the Chamber, I'm here to express our support for this project. This project is the right project for the right place, and it's time for it to come to fruition. The store will provide a service to the community, as you've heard, while generating dollars for the economy. Personally, I know I go in and spend $5 and I end up spending $100, as happened to me this weekend, and I know that's magnified by many. The store is expected to also create 75 construction jobs and employ over 250 people once it's open, and provide a spot for local businesses to open up retail and restaurants on the ground floor. It'll also provide needed access to affordable food, clothing, and household goods. It'll improve the quality of life for East Hollywood community. Target does take an interest, as you heard, in the community. They've been a great supporter of the community, as you've heard today, and we believe that it is time for this project to get approved, and we ask for your support today.
Hello there. I'm Chancey Martorell, Executive Director of the Thai Community Development Center. Back in 1998, we were actually contracted by City Planning Department to mobilize various stakeholders and ethnic communities to come around the creation of the SNAP vision, the specific plan vision, which became the 20-year vision and the guidelines for SNAP. And the goals are pretty monumental and will help us really create the walkable and thriving community that we want to see. And in fact, now it's being used as a model to promote equitable development and prevent displacement and gentrification. And then when I was a commissioner at the Central Planning Commission, Target came before me, and we made concessions on the height and parking, knowing that we at least could get childcare and some other public benefits like local hiring. Granted, we don't want the eyesore that we see today and the blight that this may create with this half-built Target, but it must live up to the SNAP guidelines. Thank you.
Thank you. Laurent Gubler, Donnell Dadigan, Herman, Wayne.
Good afternoon, council members. I'm Laurent Gubler, President and CEO of the Hollywood Chamber of Commerce, and we are here today to support the recommendations before you. The overwhelming majority of Hollywood residents want the Target finished, and they want to be able to shop there. In all of the places I visit, I get more questions from residents and businesses about when the target will be finished than anything else. There is a lot of interest in seeing it finished. We believe the recommendations will actually be an improvement on the SNAP ordinance, which did not anticipate today's urban modeled projects. And there have been circumstances that have changed since the project was originally proposed. Within the last year, 2 new mixed-use projects have been announced, and a third is now anticipated that surround this site, and they will each be 6 to 7 stories in height and up to 75 feet. It does not make sense to require the target to be reduced in size when it is surrounded by 75-foot tall mixed-use projects. Let's get the project approved and let's get under construction. Thank you.
Thank you.
Good afternoon. My name is Danelle Dadigan. I am president of the Hollywood Museum in the historic Max Factor building in Hollywood. As a business owner, someone who comes to Hollywood daily to work and who lives in the area, I would want to say that we would like to see a Target in our neighborhood. I'd like to say that we would enjoy being able to shop and enjoy the opportunity to shop in such a wonderful business as Target without having to go out of the area. On behalf of many business owners, I would like to say that we would like to shop in Hollywood in a Target and not have to go out of our boundaries to go to the next nearest Target in West Hollywood. Thank you.
Thank you. Herman, Wayne, Alex Kondrak.
Highly to succeed. The mixed use of negative declaration and required approval of the project with no EIR for mixed use. General plan amendments to the Hollywood Community Plan. I find that an embezzlement, theft, forgery, falsification, and fabrication of records under the perjury of fraud, bribery, and collusion, and a conspiracy to defraud the public in the land use. So where do we come up with these guidelines to protect the public? I can go anywhere to Target, mother. I can go anywhere to Target. I can find a Target in Watts. I can find a Target South Central. So why do I need another Target in North Hollywood when I can't even live in North Hollywood? Are you kidding me? Give this nigger a break.
Wayne?
Yeah, black folk, yeah, we know all about this shit. We're here to support the people of Hollywood. Hollywood! And we're here to support the people who live in affordable housing. Marquise knows Judge Fruin. Judge Fruin said, no, motherfucker, no general plan amendment to the Hollywood Community Plan can be done this way. So you got to take the bulldozer like Item 1 in the earthquake. You got to tear that shit down. That way you teach these niggas how to do the right planning. They do the right planning. You build it, you violate the law, you say you need it, and you let it stand. Then that means I'm going to put condos on the top of this fucking building and get away with it. You shoot my black ass. Support this, vote no on this whole fucking thing.
Alex Kondrak, and then Chris Robertson from Council District 13.
Hi. Target's providing jobs, but the jobs that they're providing are minimum wage jobs. Concessions were made. You heard from the woman from the Central Area Planning Commission. She told you that concessions were made based on the fact that Target was going to provide child care. Another gentleman talked about other projects that were approved that didn't comply with the SNAP, but those were providing residential housing. Those were not businesses, they were residences. I'm a mom. I don't know if you guys have any idea how much child care costs. The going rate right now is $25 an hour. these jobs are going to be minimum wage jobs. These women and men who work at this Target will not be able to afford the childcare, but Target, which makes billions of dollars a year, can afford it. Make sure they provide it. It's part of the SNAP guidelines. There's no reason they should be able to get out of it.
Chris Robertson, Council District 13.
Good afternoon, council members. Chris Robertson, Planning Director for Councilmember Mitchell Farrell of the 13th District. It's been a long journey to stand before you today to express our strong support for this project. Since construction halted, the site has been a major eyesore and a constant reminder to the community of the bureaucracy and challenge of doing business in the city. Our office receives dozens of phone calls and emails every month from constituents who support Target and can't wait for it to open. It is critical to the councilmen and the community who overwhelmingly support this project that we approve this request and move Target forward as quickly as possible. We need to see this building back under construction, and we need to see it quickly. This project will bring economic vitality to an area that desperately needs it, bringing an active retail experience to one of our major commercial corridors that will serve thousands of people and bring hundreds of entry-level jobs to a socioeconomically diverse neighborhood. As you may know, there's been an extensive conversation around the issue of child care and Target's plans to meet the child care requirement outlined in the SNAP. While we greatly respect the intent of the Commission's action, it left too many questions unanswered and too many details to be sorted out. The fact is, we have a building that is half finished, and it makes no sense to delay the project from moving forward in an attempt to make a larger policy statement. As such, we have circulated an amendment to the CPC's action, which we hope that you will support. We simply aim to reinstate the language in the existing SNAP so that Target has the ability to request the use of the in-lieu fee that is currently allowed. It is important to underline that the city would not be taking an action on the use or amount of the in-lieu fee, nor is this within the purview of City Council. It may only be approved by the Rec and Parks Board. While SNAP allows for an in-lieu fee procedure and requires Rec and Parks to make final determination, it provides little to no guidance on how Rec and Parks is to calculate or determine the in-lieu fee. The applicant had previously submitted an in-lieu fee study. However, the city does not have the resources to review its adequacy. As such, our office worked with the CIO's office to release an RFP for consultant services to peer review Target's study. The councilman also introduced a motion authorizing the CIO to enter into a contract with the to-be-selected consultant and accept the necessary funds from the applicant so that there is no financial impact to the city. This motion was approved in council this morning. This approach will enable the project to move forward and ensure the city has the information it needs before taking on action on the use and amount of an in-lieu fee. We are confident that in the end, the project will result in an increase in child care services to accommodate the needs of the project employees. With that, we would like to thank the Planning Department, especially Blake Lamb and Shauna Bonston, for their work on this project, and respectfully urge the committee to uphold the CPC's action with the exception of the general plan amendment as withdrawn by the applicant and with the modifications that I circulated. And I'd just like to take a minute to clarify that the amendments to the ordinance would be section 6, subsection G4. And I would request planning clarify that if the committee has any other questions. Thank you very much, and I'm available if you have any questions.
Thank you. And George Abrams, I omitted to add you your 1 minute.
Okay, first of all, I object to the late addition by the applicant into the record, not giving the appellants an opportunity to analyze and object to the specifics. There is overwhelming support for a Target. I support a Target and all the appellants support a Target, but there isn't overwhelming support for breaking cities' planning laws. And also Target's actually doing a disservice to its shareholders. Basically, think of all the revenue they've been losing by trying to double down on a losing bet. Right now, Marshall's a block away, which did comply with SNAP, is eating Target's lunch. Target should tear down the illegal structure and build the SNAP compliant project they originally planned. In fact, all developers should stop listening to Garcetti and start listening to the community.
Thank you. Staff, if you could come up again, please. We may have some questions for staff. So the specific plan provides a provision that allows an applicant to provide child care facilities or pay an in lieu fee. how do we determine what that in lieu fee should be if that's the direction we go in?
Shauna Bonson, City Planning. Oh, it's working. Your question, and I was a little distracted because I was making sure the mic was working, was how to determine the in lieu fee?
Yes.
So the in lieu fee has been proposed. Target did an initial study. Hello?
It's on.
Okay. And then, as was mentioned earlier, the CAO's office is coordinating to do a consultant to do a peer review of the analysis.
I'm sorry, can you repeat that?
It is done by the applicant and then a peer review to determine the fee.
So the applicant conducts the study, and there's a peer review, and who
They have consultants to do the study, and then that's reviewed by a third party.
Okay. And that's done after all the approvals?
As proposed, that's being done concurrent.
Concurrent.
Correct.
But is there some rules as to when, I mean, because if we support moving to an in lieu instead of actually constructing the child care facility, how do we know if we feel that's adequate before we even support that? Or is that...
I believe that was one of the items that was mentioned by an appellant as to whether that takes place prior to the certificate of occupancy or prior to the building permit. I believe the recommendation by the City Planning Commission was prior to certificate of occupancy, so there was time for the studies and or the location, the provision of physical construction to take place.
Okay. And, okay, any other questions or comments on this item? Okay. Well, colleagues, as you know, we previously granted a continuance for this item to allow additional time to resolve an issue relating to the community benefits and particularly the child care facility. Here we are now looking at the child care facility issue, and if there are no other questions or comments, I'd like to ask that we grant in part and deny in part Target's appeals and deny all other appeals. That we adopt the CPC's report with regard to CEQA, amend the specific plan to include Council District 13's desired changes, and refer the item to the City Attorney on the language, and adopt the findings and recommendations of CPC except as amended here today. Mr. CLA, did I miss anything? If that's the direction we wish to go in, any technical?
The only other remaining issue, I think it was the withdrawal of the general plan amendment by the applicant.
Okay, that's right.
But City Attorney says you don't need to act on that, but for the record, that was withdrawn.
And that was noted by the Planning Department. That was in the City Attorney's office, if that is a desire. And Council District 13, you're fine with that? Where are you? Yep. Okay, so we'll just note that, if that is the appropriate way to do that. Okay, thank you. Any objections to that? Seeing none, so ordered. Okay, thank you. Is this in council on a certain date? Date certain?
I believe it's in council tomorrow, Council.
It's in council tomorrow?
Yes, sir.
Okay, thank you. So noted. Thank you very much. Next item?
Next item, Councilman, is a CEQA appeal filed by Mark Kenyon from the Mount Washington Homeowners Alliance. It relates to the construction of 5 single-family dwellings on 5 contiguous lots in CD1.
Staff here to present on this item.
Good afternoon. Mr. Chairman, members of the committee, Greg Shoup representing the
One
Planning
second,
Department.
please. 1 second. Can our audio, seems to be some disturbance in our audio. You need a moment to look at that, or should we proceed? You okay? All right. Thank you. Okay, go ahead.
The item before you is an appeal of 2 initial study categories, land use and geology grading, that are part of a mitigated negative declaration adopted as part of the approval process that will result in the construction of 5 single-family homes on 5 legal record lots in the Mount Washington Glassell Park specific plan. Both the Director of Planning and the East Los Angeles Area Planning Commission on appeal determined that the initial study and resultant MND fully analyzed any potential significant direct or indirect environmental impact on the environment that may occur from the development of these 5 homes. As stated in a letter submitted to the committee, staff will not respond unless asked by the committee on the document entitled Mount Washington Homeowners Alliance, an analysis of why city planning has no lawful impediment to enforcement of the Northeast Community Plan and RE11 zone. This set of arguments we looked at was identical to what was submitted to the Area Planning Commission as appeal points. We responded to that in our accompanying staff report, and based on that information and the discussion at the public hearing, the Area Planning Commission rejected those appellate points from the Mount Washington Alliance and denied the appeals and sustained the action of the Director of Planning. At this point, we don't feel that that's necessary to revisit those issues unless it's the desire of the committee. In order to make a fair argument challenge to this MND, the appellants are required to provide facts, evidence, and expert opinions based on facts that construction of these 5 homes on legal record lots will have a significant impact on the environment that cannot be mitigated, and therefore the applicant either must prepare an EIR or design the project so that it can be mitigated. Okay. Part of our initial study process, we look at 18 environmental factors. We have a very large book, which is, for our initial study, consistent with State Environmental Quality Act. We look at all these different factors in analyzing a project. We look at traffic, we look at grading, we look at geology, we look at hazards, we look at air quality, we look at aesthetics, all these issues. And we come up with a recommendation we feel will be supported by the SWECO law. The appellant's position is that the initial study checklist failed to identify 2 impacts caused by the project, one on the land use section of the initial study and one on the grading or geology section. In Exhibit A, which you have retained a copy of, that's a copy of our thresholds, what we look at when we're analyzing a land use impact. One of the land use impacts, for example, could be if a bridge or freeway is going through a neighborhood and it's going to divide the neighborhood into a north and south, and this is a neighborhood that is very tight and compact. That could be an environmental impact because it's going to affect the land use. These people aren't going to be able to go back and forth between like they used to because they'll have a freeway or a bridge or a waterway or something between. We also look at if the project is inconsistent with the general plan. In this case, this project is consistent with the general plan. The RE11 zone is a corresponding zone to the very low land use designation. It's also consistent with the specific plan. The specific plan has to be consistent with the Northeast Hillside, Northeast Community Plan. The Northeast Community Plan has to be consistent with the housing element, transportation element, and the framework element. So all these umbrellas, so to speak, go down to the single-family level. So them arguing that it's not consistent is incorrect. What would be more of a impact that we would look at would be that in the RD5 zone, which is allowed in this area, would allow a zone change to these homes to RD5. RD5 would allow for multifamily development, boxy type apartments that we typically see in more of the infill area. And that I would think we would look at as incompatible with a bunch of single family neighborhoods. Just parachute in a boxy apartment building, even though the zone would allow it. We would look at that as a land use impact that could have a significant impact on the surrounding community. And a way to mitigate that would be require the developer to build it similar to small lot homes or a detached condominium project. So it would look and feel like a single family home. So it would blend in to the complex. As regard to grading and the geology, it is true Mr. Patrick Cassidy, a licensed architect, did present testimony at the Area Planning Commission appeal, hearing that in his opinion the amount of soil being exported was too low. He submitted in this Exhibit B, during the back and forth discussion staff had and the commission staff, it really was more of a back of the envelope calculation versus a real calculation. Staff asked Mr. Cassidy, and I was the staff, if he had reviewed the soils report or the soils approval letter issued by Building and Safety, or the grading plan, which is also approved by Building and Safety. These are all public records and were available for him to review. He stated that he had not, that this was just his personal opinion. It also could not tell the Commission if the increased amount of soil being exported would create a potential significant impact on the surrounding neighborhood. Lastly, when queried, he was unwilling to stamp his drawings. He would have put his AIA stamp on there as an expert, saying that these calculations are true and correct, and was submitted as a counter-argument to Planning's review and the Grading Department's review of the amount of grading. What you're looking at is about 3,145 cubic yards of dirt, which will translate to about 311 truck trips going up and down. And that could be an impact. That could be, but it's a temporary impact. And the impact could be mitigated. One of the mitigation measures that we propose is that when we looked at the 5 individual lots, each lot is taking off the property, which is the exported dirt, about 350 to 750 in that range. 350 for one lot, 750 for another lot, 850 I believe for another lot of dirt. Individually, they would not require a haul route. Haul routes are required by building safety if you're mowing down 1,000 cubic yards of dirt. You have seen haul route approvals and haul route reviews of the MNDs, and so what we looked at is how would we look at this as one big project. Since the MND looked at all 5 homes as a project, after talking to Building Safety and the City Attorney, Planning came to the conclusion that we could ask the Area Planning Commission to impose a haul route condition on these 5 homes. So it'll be one haul route. It'll deal with the hauling of the 3,145 cubic yards of dirt. Building Safety will then evaluate it. They'll regulate it. LADOT will regulate it. They'll regulate the amount of trucks coming up, the type of trucks, how long the trucks could come. And so we feel that is sufficient mitigation that so we've done our due diligence, and the city has done their due diligence.
Is that a condition? Is it?
That is a condition in all 5 of the applications.
It's in the application.
It's in the approval letters.
Added in the Area Planning Commission?
Yeah, their determinations. In conclusion, the appellants failed to provide the required facts, evidence, and/or expert opinions based on facts that the construction of these homes will have an impact on the environment. I'm here for questions.
Okay, Mr. Cedillo, do you wish to speak now on this, or do you want to go to public comment?
Council members, you have the appeal to be heard. I don't know if you want to take that before taking public comment.
Well, we'll hear the appellants.
Oh, okay. Sure.
Which one is the order?
Let's go to hear the applicant and the appellants. Then. Okay. Mark Kenyon.
Testing. Thank you, council members. Mark Kenyon on behalf of the Mount Washington Homeowners Alliance. So I'm just going to focus on the general plan issue since I have such a short amount of time. So
Mr. Kenyon, you do have as the appellant 5 minutes.
Yes.
And then all other speakers have 1 minute.
Okay, thank you.
The applicant has 5 minutes as well, but you as the appellant have 5 minutes.
Okay, great. Okay. Thank you. Yes, so I'm going to try to
so I'll clarify
5
that
minutes.
before. Okay.
Yes, thank you. Appreciate that. So I'm going to focus, because I have 5 minutes, on the general plan issue. This issue is complicated and is many decades in the making. So we're objecting to the fact that the initial study checklist checked for item 10, land use and planning, number B, no impact. That item reads, conflict with any applicable land use plan, including a general plan, adopted for the purpose of avoiding or mitigating an environmental impact. When we created the Northeast Community Plan, the city went through an EIR process, and as part of that process, they determined or adopted a mitigation measure which downzoned, or rather redesignated the land use in many areas in the plan area, in this case, to very low density in the RE11 zone. So these loans were downzoned pursuant to a mitigation measure. So it's completely, unlike staff just told you, exactly, there's a land use plan here. The general plan says that this should be very low residential. And what's the proposed project is just for low residential. The reason why the city adopted the downzoning for these lots was because it determined as part of the EIR process that the infrastructure was inadequate in the Northeast Plan area. In fact, at that time, the planned population was for 460,000 people. The general plan, through the designation of the the lower density is to accommodate 256,000 people. The state law, as we say in our submittals, requires the city's zoning code, its zoning ordinances, to be consistent with its general plan, not the other way around. The planning department is purporting to use code sections 1222 and 1223 to implement the plan, to not implement the reduced density. And I would just like to read to you from a Supreme Court case that we put into our filing, into our submittal, called Lesher Communications versus the City of Walnut Creek. And to quote the court, they said, "A zoning ordinance that is inconsistent with the general plan is invalid when passed, and one that was originally consistent but has become inconsistent must be brought into conformity with the general plan. The tail does not wag the dog." And in our, what we're looking at here is that by using sections 1222 and 1223, the city is in fact wagging the dog. And we object to that. We think that the infrastructure that we're concerned about is the roadway systems in Mount Washington and the ability to have access to emergency vehicles, fire safety, and other types of services that the community deserves and should have. So we don't think that the city should be allowing these sections to trump the general plan. So we would ask you to reverse the adoption of the mitigated negative declaration, to reverse the determination of the East Los Angeles Area Planning Commission, and to remand this matter back to City Planning Department for further proceedings that would be consistent with the general plan, with the underlying RE11 zoning, the Mount Washington Glassell Park Neighborhood Specific Plan, and then finally Government Code Section 66451.11, which is in accordance with the California Supreme Court's interpretation of a case called Morehart that we put into the record, where Morehart would allow the city to require the developer to submit plans that conform to the RE11 zone. So in this case, there's 5 lots. He could. We haven't actually done the analysis, but it looks like he could build 3 houses or maybe 2 houses, and that's what we would recommend. We think this issue is citywide, not just in Mount Washington. There were over 200,000 lots that were downzoned as part of what was at that time called the AB 283 process. This is a public safety issue, so either implement our general plan or build our infrastructure. Thank you very much.
Thank you.
Oh, one last thing, since I've got a couple seconds. I put in a PowerPoint presentation which summarized the things I just said. At the end of that is a chart where I went to the U.S. Census Bureau, and I've put in for the 2010 census for the plan area and the 2015 estimate for the plan area. And the estimate for today is that we are over the plan amount. So the amount of population in the Northeast plan is greater than right now than what we planned for. Thank you.
Great. Thank you. Does the applicant, I didn't find a card. Was the card submitted for the applicant? Yes. Do you wish to speak? The appellant just spoke. And after you speak, sir, if you could fill out a card just for our records. We do need one for our records to verify that, in fact, indeed you
Sorry about that. I'll
are
get you
who
the
you
card.
are. Thank you.
Mr. Chairman, council members, my name is Jeremy Brust, and I'm representing the project applicant who is here with us today, Naji Garabat. And as you heard earlier, this is a project that's been here before, and specifically these issues have been here before. This is a retread of some land use issues that were appropriately considered through the application process and the appeal process for the initial permit review, and now they have been repackaged as CEQA issues when it's time to consider the mitigated negative declaration. The project permit compliance review was required to go through all of the land use requirements, and those were all thoroughly considered again on appeal, including the issue of consistency with the general plan. As was noted earlier, we have an RE11 very low density residential density designation, and that has been on the books for some time. And there have been really no other actions here. This was property that was subdivided back in the 1920s, and since then has remained undeveloped. And the applicant's wish now is to develop houses on lots that were intended for houses. That remained the case through the 1970s, which is where the appellants are reaching back to find some sort of purchase on the CEQA argument to somehow find that residential is valid, but only if it complies with their interpretation of the general plan. It's important to remember here that the general plan is a guiding document that is then fleshed out by the land use and zoning laws. And in this case, the procedure that's prescribed by the law to go through the application process has been completed and has been thoroughly vetted on appeal. The crux of the argument that's being presented by the association is that there is a mandatory set of mitigation measures from the EIR in the 1970s that have remained frozen in time and insulated from any changes that require that basically forbid any future changes to the vision of low density or very low density that they believe was in effect at the time. There was even discussion in the material that they submitted about mandatory lot mergers, and there is no support for that anywhere in the law, nothing cited from the Subdivision Map Act that would require 90-year-old parcels to now be merged together based on a 40-year-old environmental impact report. This is simply an opportunity to reach back and try to find some opportunity to hang old rejected arguments in some new posture. And as was discussed before, the review process and for both land use and for all of the environmental issues, even though the MND is on for, was the second action that was taken, and that's the concern of the appeal now. The environmental issues were all addressed at the initial stage, and most importantly, there is nothing new here. There are no new arguments, there's no new evidence, there is conjecture, there is speculation, and that's not good enough under the law. We had speculation from a friendly consulting engineer, I suppose, about the grading issue, but we stand behind the grading plans. They were approved by the Department of Building and Safety, and they show that the volumes of excavation that are anticipated are correct, and that there should be no grading bust, as was the specter of which was brought up both at the last appeal and again now. Those are the only points that I wish to hit. It remains our position that the fair argument standard has not even come close to being matched by the appellants, and that the appeal should be denied. And if there are any other questions, I'd be happy to entertain them. Thank you.
Thank you. Monique Gaudry, Daniel Wright, Eileen Spach, Adolfo Reyes.
Good afternoon, Monique Gaudry, resident, homeowner, Mount Washington. I have lived on Mount Washington since 1976, and we've had our battles too. We've had to fight some significant battles, but this is disturbing to me because we don't have the infrastructure to support this kind of development. Very quickly, about 15 years ago, or perhaps a little longer, we had a very serious fire, 11 Elyria Drive, and a fire, burnt the two canyons on each side of the street, and we almost lost. We could have lost our house if the emergency vehicles had not been able to reach the properties. Our house was saved, our animals were safe, and we were okay. Not the same thing happened 2 years ago on a small street on Mount Washington, where an elderly gentleman lost his life in a fire. So as a result, we feel that the infrastructure does not support a cluster of homes in an area that could threaten the lives, the health, the environment. Thank you.
Thank you. Daniel Wright, Lynch-Bach.
Good afternoon, Daniel Wright, 467 Crane Boulevard, Los Angeles. The standard has been met with respect to CEQA because this is a violation of the general plan. There is an undisclosed, unanalyzed violation of the general plan, and therefore you do not have the authority to use this mitigated negative deck to approve this project. And the reason for that is that the project has an irreconcilable legality problem, and that is that inconsistency. What the staff tries to say is that two exceptions in the zoning code, which are subordinate to the general plan, trump the general plan. That is not true. With regard to protection of rights, the California Supreme Court, I'm quoting, has said, landowners have no vested right in existing or anticipated zoning ordinances. And so, therefore, there is no vested right to a lot. There is a vested right to a use. If you've built something, this is vacant land. There is no vested right here, and our proposal is consistent with law as detailed in the memo that I've given to you. Thank you.
Thank you. Lynch-Bach, Adolfo Reyes, Jack Fenn, Christopher Howard.
Good afternoon. I'm speaking in support of the appeal, and so is my community. I'm in Glassell Park. We deal with the very same issues because this is a citywide situation that we're dealing with. I work with the Glassell Park Improvement Association, and in particular, we have taken this up with Barry Knoll, which is the very similar situation that we're dealing with. We feel that this is not just about quality of life for current and future residents. It's primarily a safety issue. So that the over-densification was what was supposed to be mitigated through the down zoning, and without proper mitigation, we still face the exact same problems and potential deleterious effects in emergencies that the down zoning was meant to address. Without proper mitigation, which we don't see, we're still dealing in the exact same situation as we were before. And so I simply want to impress upon you that we're supporting Ganymede because it's the same issues that we deal with in our community and many others. Thank you.
Thank you. Adolfo Reyes, Jack Fenn, Christopher Howard, Herman, Wayne.
Thank you. My name's Adolfo Reyes. I live in the area at 864 West Avenue 37. Councilman Cedillo is part of the committee here, and he knows the area, the convoluted, narrow, inadequate streets that are all over the Mount Washington area. There's construction projects going on in the area, and frequently, more often than not, developers do not comply with stated mitigation that they said they were going to comply with respect to closing of streets or bringing material or just stopping traffic. You can't drive through. They don't even post signs. Now, for the rest of the council people that don't live in the area, you're not familiar, so you don't know. But Councilman Cedillo knows how bad that area is. Those lots proposed for these projects should be merged, and no more than 3 units should be allowed.
Thank you.
I support the.
Thank you, sir.
Okay.
Next.
Mr. Chairman, members of the committee,
I'm Jack Fenn. I live in Montecito Heights, adjacent to an area of open space with about 120 unbuilt lots, all substandard in RE20 zone. I believe that the 5 homes that are being proposed here actually have a significant environmental impact in 2 ways. They double the density for a neighborhood, and that goes contrary to the zoning of RE11. That impacts the infrastructure, that impacts everyone's daily lives. It also impacts the environment from the natural standpoint too, because each house, and these are 5 small mansions, each house takes up a lot of space on the lot. It doesn't allow for the open areas that are a hallmark of that area with its beautiful open spaces, plant life, and animal life. And these elements must come into play in consideration also. And I see the same thing applying to Montecito Heights with the same kind of zoning issues. Thank you.
Thank you.
Good afternoon. Christopher Howard, Vice President, Membership, Mount Washington Homeowners Alliance. In a recent email to Alliance members, our Land Use Chair, Mark Kenyon, stated that the general plan reduced the density of Ganymede lots from R1 to RE11 because the city determined infrastructure of all types in northeast Los Angeles was inadequate to handle the then planned population of over 450,000 people. The city made a decision that became the central part of the general plan to reduce the planned population to approximately 250,000 people by reducing the zoning density, that is from from R1 to RE11 to a level that the infrastructure could handle. And I'm not going to be able to get through all of this, but I just wanted to say that our neighbors support the minimizing of the impact on our infrastructure in Mount Washington and northeast Los Angeles. Thank you.
Thank you.
Obviously, there's some inadequate specific plans for northeast Los Angeles plan area
One more after him.
where public safety and hazard construction obviously has been trumped with illegal land use, causing a negative land use impact, causing density to mansionization. Us fucking Negroes don't live in mansions. We work in those mansions. We work in those mansions, us Negroes. That's why it's inadequate. Inadequate Negroes can only work in mansions, and all you do is trump, just trump on the illegal land use. Public safety and hazard construction. Please, Mr. Chair, you must stop this project at once and review the records for public safety and hazard due to the illegal process of construction.
See, the problem here, the community say, no, we don't want this shit. So that should be the end of it. Project dead. Why you gotta buy 5 houses, McMansions, on the side of a slopey hill? Because these are developer motherfuckers trying to take advantage of an overhyped, overmarketed production of housing in a ridiculous bubble. This shit all about a bubble. It go bubbling. The minute that motherfucking stock market go down, these 5 houses ain't worth a shit, and the bank will take them back. These people here don't want it. 5 is too many. 2 houses is cool. 3 houses is a fool. 4 houses is crazy. And 5 is a knife in the back of these people. Vote no on this bullshit. Give them 2 houses, not 5.
Thank you. Mr. Cedillo, this is in your district. You wish to speak start the conversation?
Yes. Can we have planning come up and respond to the major points that were asserted?
Again, the issue is that what is consistency of the general plan? The consistency of the general plan, when they were doing the land use plan, because I was part of that program, we had AB 283 program, which downzoned and up-planned and down-planned. We had the community plan update, Division 1 and community plan update 2, where they started reducing the overall potential to come down to what they call the theoretical population. In these areas, that resulted in some of the down zones, from R1 across the street to this area, RE11, which today would require 11,000 square foot for new lots. This was to keep, this zone was to keep subdivisions. There's large tracts of undeveloped land still in the northeast area, in the Mount Washington area. By downzoning these to RE40, 1 unit per 4,000 square feet, RE20, 1 house per 20,000 square feet or 1 lot, or RE11, 1 house per 11,000, was to keep further subdividing these large 4 or 5 acre parcels that aren't legal existing lots, but vacant large acreage to smaller R1 lots that they would be, we have one like an Onyx, for example, where that would be RE40. Those would be probably, if they're R1, you could probably get 30 lots there. RE40, you can get 3. That was the purpose of the down zone. The down zone also recognized that you have a legal record lot. You have a right to build on a lot. And where Mr. Kenyon is talking about R1 versus an R1 use versus an R11 use, in our zoning category it says in R11 you can construct a single family house. In a R1 zone you can construct a single family house. So we don't know how he can make a distinction between a R1 single family house and a RE11 single-family house. They're both single-family houses. Now, what the Mount Washington specific plan does, the specific plan has reduced, when they're talking about these McMansions, they reduce the ultimate size of these homes. These homes are based on a formula based on the size of your lot. If you have a 5,000 square foot lot, you're only allowed to build a 2,500 square foot house. And if you have a 400 square foot garage, we count the garage. We count a basement. We count everything within the 4 walls of that building. So even though your neighbors say this is a larger home, the homes next door, for example, are 3,000 to 4,000 square feet. These will be about livable anywhere from 1,900 to 2,200 square feet. These aren't going to be very large homes. Also, they're going to reduce, they're not going to overgrade the property. Grading takes time and costs money. They're going to use the existing topography and the height and build into these upslope lots, minimizing how much dirt they could take off. The other issue is what people talk about, that there's no fire protection, there's fire safety issues, there's roadway issues. In CEQA, these are base conditions. These conditions have existed throughout the 50, 60, 70 years, 90 years that this area has been lived in. What CEQA looks at is, will this project exacerbate the existing condition? We have this conversation every time with the developers, the community, the Area Planning Commission, and especially when it comes to fire protection. These homes are required to have fire retardant roofs, boxed eaves, tempered glass, dual pane tempered glass, made out of fire retardant roof, sprinkler systems, and so forth. So the idea that they will create a fire hazard is preposterous, because they're safe homes. If you build on these lots, then these aren't vacant lots that will get a grass fire or wildfire that will run up the canyon. These are lots that now people have homes on. Homes that were built 20 years ago don't have fire sprinklers. They probably have wood shingled roof still. They may have fire retardant or single glass that blows out in a fire. So again, the MND looked at all these issues, came up what we consider mitigations that would mitigate any of the potential impacts to less than significant. Councilman?
Okay, thank you. Mr. Chair, you know, you're our neighbor here. In the 14th, we share unique districts, some that are working class, and there's appropriate places for multi-unit housing. And then we have other areas like Eagle Rock or Mount Washington, Montecito Heights, LaSalle Park, that aren't set up for that they're challenged, in fact, because of the topography. But those are existing conditions. narrow streets, difficulty to ingress, egress, and not, as I said recently at a homeowners association meeting, probably not appropriate for any development that's multi-unit. On the other hand, there is and do exist lots that are appropriate for single unit development. It is what it is. I mean, that is the case. Now, we have been very careful and thoughtful about that. In fact, we actually took one area, Flat Top, off the market. And we have now moved to make that an area that is preserved. There will not be development there. The development, if any, in Montecito Heights is modest. This is a discussion about 5 units versus 3 units. So it's an argument that says that these 2 units and that this 2-unit difference is what makes a big difference and changes the entire world. I don't think that that's the case. And the fact of the matter is that every day I get up, I think about how the city's going to build 100,000 units of housing. I'm chair of housing, and that's what preoccupies me every day. Where and how are we going to do this? Well, we're not going to build significant amounts in Mount Washington. But that doesn't mean we're not going to build any. That doesn't mean we're not going to build any in Glassell Park. Doesn't mean we're not going to build any in Montecito Heights. We will build single-unit housing there that's appropriate. And we have laid out this proposal. Seems to be consistent with what's appropriate. A general plan is just that, a general plan, a guiding document, a living and breathing document for which then we, the city, the community, all the other entities that are involved in the governance of the area have to apply that vision in a way that makes sense for each distinct community. And in this instance, I believe that we've done that, and that I'm prepared for us to move forward and to, what is the appropriate phraseology here? Deny?
To deny, Council.
And that we're prepared to move forward and to deny the appeal. I thank you for the thoroughness of your evaluation of this. And I thank you for the mitigations you've made. So, for example, in this committee in Plum, we constantly see these skirmishes and battles taking place on the west side. And I think we've learned from that in terms of how you grouping together the 5 lots so that we have that type of mitigation to make sure that the soil is moved in a way that's not disruptive to the community, and done so in a way that you have delineated by looking at the lots as one huge lot. It's a very thoughtful mitigation on your part, and we appreciate that, and that's appropriately integrated into this plan. But with all that said, I move that we deny the appeal.
Councilman, we also need to adopt the recommendations and findings of the East LA APC.
Yes, and in so doing that we adopt and embrace the findings and conclusions of the East Los Angeles Commission report.
Okay, there's been a motion by the council member of the district. I do have 2 questions. One is, you mentioned that there's a R1 and an R11, and both instances we could build single-family homes. What's the difference between the 2 characterizations?
It's just the size of a lot. An R1 zone would be 5,000 square feet, 50 feet wide. An R11 zone has to be 11,000 square feet, 60 feet wide. RE20, for example, is 20,000. So this, when you apply to existing lots, no matter what their size, our zoning code allows you to build legally on these non-conforming lots. You couldn't further subdivide that 11,000 square foot lot because it's too small. But if you were going to take the same acreage, same 43,000 square feet of 1 acre, you would get less homes in an R11 zone than you would be in an R1. So we were zoning that for the future to keep the developers from taking like Flat Top and Araya Canyon and developing those into smaller single-family homes, that they would have to be larger homes. So we're looking towards the future of reducing the density. It was never intended that people can't build on legally buildable property, especially on a subdivision that's identical to what's across the street. R1 and R11, these were all subdivided in the 20s, identical at the same time.
So they have vested rights at the lower at the lower density, right?
Well, there's still going to be one house on one lot. It's just that the lots are smaller than 11,000. So they're non-conforming as to the size of the lot, but they're still buildable.
I see. Okay. And my second question is, so we have in the conditions of approval, haul routes, how about staging?
Yes, as part of the mitigated negative deck, they have several things. We've added a mitigation measure for hillside staging and construction. They're obligated as part of their mitigation that are incorporated into each 5 project permits. So if they build all 5 at the same time or they build 1 at a time, they still have to comply with that. And that's going to regulate the staging of the equipment on the property, not blocking the roadways with concrete trucks and so forth. As part of the haul route, since we're, as the councilman said, Councilman Cedillo said, all 5 houses are going to look at one project and one haul route. They're going to be subject to building safety's haul route process. And in my exhibits that I gave you, the last exhibit is called what's called a good neighbor policy. Building safety has put that together. They hand that out to the community and the developers, and that basically informs the community. Here's the rules the developer has to abide by. If you see these violations of these rules, call 311 and report the project. So if a cement truck is blocking longer than it needs to be, you can call the building safety inspection. You can call the appropriate city agency that will come out and respond to that. That, I think, has done a lot for, and we're starting to incorporate those conditions and mail those to the neighbors when we do project permits. When we do project permits in Mount Washington, we mail those to the neighbors. So now the neighbors have a set of rules. When the developer says, well, I don't have to pay attention to stacking lumber on the street, they can point to that and say, no, it's a violation of the city zoning ordinance, and I'm going to call the Bureau of Street Services on you. So it is self-enforcing. And we think with all those measures in place, this will be a project that will be compatible during the construction phase with the community.
Thank you very much. Okay, is there any objection to Mr. Cedillo's motion? Seeing none, so ordered. Okay, thank you very much. Next item, please.
Public comment, Council. Public comment.
Public comment, okay. On public comment, first up is Wayne and Herman. Wayne and Herman, I missed your cards on item number 1. If you agree, I will provide you that minute under public comment. Is that okay with you? Or you don't want that minute? Wayne, why don't you come on up and speak? You want the 2 minutes? Go ahead, you have the 2 minutes.
So once again, the community loses. Everyone lost, except the well-heeled. There needs to be a balance between the community and the developer. Right now, it's all tilted in favor of the developer. The community doesn't have a say. What does that lead to? Revolution. That's what it always leads to. It's going to lead to Donald Trump being elected president. It's going to be an absolute bitch because you're going to have a new law next year. They're going to put a halt on all development. Later, the repercussions from this will be felt, horribly felt. People that want affordable housing won't be able to get it. Good projects will die because the scales will tilt back sharply the other way. That's our country. That's the way we work in this country. That's why this country will survive. Even that little puppet behind you, Herb Wesson, the puppet, we will survive the puppet. And we will survive this. This is a travesty. You redline entire zones with a marker and say this is an entitlement. Magic, voila. Commissions and planning out of control. The Central Area Planning Commission 2 weeks ago, it was a nightmare. Tonight they canceled their meeting because they don't want to face me. They don't want to face the Hollywood community, what they did, Ms. Chemerinsky. So just keep in mind with what you're doing, you're crushing the people that live in these neighborhoods. You're crushing them. They're going to come back with a fury. New laws will be passed. And those new laws will be done in a way when you want affordable housing projects, no one will get them. Just keep in mind what's going to happen.
Thank you. Herman? Norman, are you going to take up your 1 minute from item 1?
No, I'm using my 2 minutes. So as you heard, development wins, you, the public, lose. You lose because a system that's supposed to work for you fails. A system of programmatic access to your rights fails you. A local government that's supposed to sustain affordable housing and recommendations for more housing in residential areas has failed you. Thank you, thank you, thank you for all the reckless failures of creating such horrible density and gentrification in our neighborhoods. This has been going on for years through the CRA, through redevelopment. We crush them, and yet you try to revive them to bring more harm, pain, and suffering to the communities that you've neglected, to the communities that you oppress. Why are there so many African Americans in our street? Ask Harris Dawson. Why are there so many people left out on the sidewalk and streets? Ask Felipe Fuentes. Vote no for Mitch Englander for County Board Supervisor. Anyone but Mitch Englander for County Board Supervisor.
Mr. Herman,
I'm regressing and coming back to topic.
Yes, I'm afraid you've
issue-
regressed a little too much in this meeting. You know the rules. You know exactly the rules. I've warned
So
you
I
already.
digress. I'm coming back
I've
to
warned you
topic, sir.
already through this meeting not to disrupt this meeting. You have disrupted this meeting again, and while you know the rules. So I'm asking you to please leave the podium. Your time is up. Thank you very much.
Thank you. Fuck
Doug
you.
Haynes.
Has everyone gotten the photos that I distributed before my time starts? The photos, so you have that so as I speak.
Yes, we got him. Thank you.
Thank you. Thank you. My name's Doug Haynes. That's a really tough act to follow, so in the future, if you could put me first, it would be helpful. The Nation magazine for this week has the lead article that says, will the Los Angeles River become a playground for the rich? And it's subheaded, the revitalization of LA's neglected riverfront has gone from social justice crusade to money-soaked land grab. The reason I bring this up is because last year we came before you on an attempt by Planning Department to skip the City Planning Commission and do a general plan amendment on a 1.3-acre parcel of land right next to Marsh Park. And the question we had is, first, this had to go to City Planning Commission. It just did. It's coming back to you. But why would the city initiate a general plan amendment to take away future potential park space? In 2004, it was zoned open space. It was dedicated to be a park, a future park. In 2005, it was purchased by Mort Lacretz, who knew what the zoning was. It needs to be retained because if you look at the photos, and if I could just finish, it's right next to Marsh Park. This parcel should be part of Marsh Park. It's a beautiful part of the river that deserves to be part of Marsh Park. We would, as a community, all of us would lose if it were not. Thank you.
Thank you very much. I see someone standing there. Sir, did you fill out a card for public comment?
I submitted a card before.
Okay. Well, you're supposed to fill out a card. So if you could fill out a card after you finish speaking and just write public comment on it. Okay. You have 1 minute, sir. Thank you.
Okay. As I said before, I live in the area, and I'm particularly concerned with this issue because I have 2 lots on each side of our...
If I could hold this time, please. And the rules are, if you are speaking on public comment, you could speak on anything that's not on the agenda because that opportunity was given to you already on that agenda item. So you could speak on anything related to land use and planning in the city of Los Angeles except items that are on the agenda that we already took up.
Okay. Well, my recommendation to you is to uphold the appeal rather than reject it. And I believe that the impact on the community would be very significant. There are a number of lots that are going to be, residents will be impacted by future development based on the action that you that Councilman Cedillo is proposing, and it's just an atrocious recommendation. He knows the area. Sorry.
Great. Thank you, sir.
Thank you.
Thank you. Any other items on the agenda? No. Seeing none, this meeting is adjourned. Thank you.